What's up, everybody? Welcome back into the episode of The Lawyer You Know, and we have the hearing on whether or not the Commonwealth is going to be able to download and search Karen Read's cell phones. We talked about the response that Karen Read's team put together last time with my dad. Well, now we have a hearing, arguments in front of the judge who is not happy. The judge is not happy, and the judge doesn't make a final decision, but he definitely gives us a lean as to what I think at least he is going to do with these cell phones at this time. But he's not happy with how the lawyers have handled this. And Turtleboy's lawyer is at this hearing as well, because this is the Commonwealth versus Turtleboy case. And he makes some arguments at the end of the hearing that really make you go, is he right about that? And if he is, do we have a bigger problem on our hands than just dealing with Karen Read's cell phones? Let's get to it. All right, so the lawyers here on the left in the tan suit is Bradle, which I think it's Bradle, Turtleboy's lawyer, and on the right or in the blue suit is Buzang, who is Karen Read's lawyer. You're going to see a bald attorney that is Cosgrove, who is the, I guess, special prosecutor on some of Turtleboy's cases, but not others. He is the one that's been disqualified, and we're going to talk more about that as we go on throughout the hearing. And this is the judge that's handling the Turtleboy case as well. So many interworking parts here that make this confusing and convoluted, but the judge makes some interesting points about how the lawyers are like two ships passing in the night as they're arguing here, and he's not happy about it. So let's take a listen to what he has to say. Make sure you guys hit that like button if you haven't already at the beginning of the video. Always helps me out, and I always appreciate it when you do that. And if you're coming around, hanging out, talking, getting in the chat, please subscribe as well.
All right, let's deal with Mr. Buzang's matter. I'm not sure that it's necessarily, well, I guess it's denominated 24SW0004, but it really is a request for setting a set of conditions for searching through Ms. Read's phone under a protocol that would assure against the sharing of privileged information. It seemed to me that the Commonwealth's request and Ms. Read's response spoke completely past each other and didn't address the merits of each other's papers, which is why I felt like I needed a hearing. As far as
what that means is you guys were just saying what you wanted to say, as opposed to responding and making the proper legal arguments to tell me what I should do. This is really more of a shot at Karen Read's team than the prosecutor, because Karen Read wants the phone backs, right? That's the initial motion. Prosecutor responds saying, we want to download the phone and look because we think there's more information in there. We had an original search warrant for it, and we want to keep investigating. Then Read's team responds with the motion that my dad and I broke down yesterday, and he's saying basically Read's response, you didn't really touch a lot of the important aspects of the Commonwealth's motion, and he's going to dig more into that, but he's not happy about it. And usually if he's annoyed at one side, it's not like he's just going to come in and rule for that side, right? So that's his first indication that maybe he's not just going to say, too bad, so sad, Commonwealth, give the phones back to Read. You can't look at them anymore. That's indication number one, but there's more coming.
I can tell the phone has already been downloaded, searched in terms of what the court authorized previously, and it just hasn't been looked at yet, and it has to be.
He's like, it's my impression that the phone has obviously already been downloaded. I mean, you guys have had this for over a year. You've had this for a long time. Clearly, you've already downloaded it. You guys just haven't taken the time to look through the paperwork that, or the report or whatever was downloaded from this phone, which is very lazy and negligent. But of course, you've obviously downloaded it. You're just waiting to look at it, and you're asking me if you can look at it. First off, logically speaking, that makes no sense. They wouldn't need the physical phones anymore if they've already downloaded it. So maybe the judge walked into this hearing thinking, it's already been downloaded. They don't need the physical phones, so I can give the physical phones back to Karen Read and allow them to look through the phone. That's kind of what it feels like his initial stance was going to be, but au contraire, my friend. Yes, they've had it for over a year, but this office, this DA's office, doesn't do what you'd think they do with information like this, with discovery like this, with evidence like this, because no, they haven't even downloaded it yet. And listen to this back and forth where the special prosecutor's like, I don't think so, Judge. And Judge's like, no, I swear I saw it somewhere here. He's like, I don't think so. Listen to this back and forth. I mean, the judge is trying to throw him a bone, but What happened has happened.
Looked at subject to a particular protocol. Do I have that right, Mr. Cosgrove?
I don't know if it has actually been downloaded, Your Honor.
If it hasn't been downloaded, that's a set of facts very different from what I understood to be the case. Because I think
So and then he says that if it hasn't been downloaded, that is a set of facts very different than I thought to be the case. So he's going to go back and forth. He's going to give us a little indication as to, I think, where he showed up to this hearing thinking how he was going to rule and maybe how he left the hearing. Maybe it's not the same. Maybe he didn't walk in and walk out thinking the same thing, because he does reserve ruling, but he says, and now he's annoyed at the prosecutor, I think. He was annoyed at Karen Reed's team at first when they came in. Now he's annoyed at the prosecutor because he's like, seriously? You guys haven't downloaded it? Why did you indicate in your motion that you did? And he's going to look through it and he's like, it's one of those things where, you know, you've read something and it's like, I remember seeing that. I remember reading something about this. And the judge feels very confident about that, but it ain't there.
I authorized the download, and I thought that there was a representation in the papers that it had been within the days of the authorization. Let me just see if I can find it in the papers.
You may have, well, okay.
He was going to make an argument. Then he's like, I guess if you find something that says that, maybe, but I don't think it has.
I think the representation is that the phones were seized pursuant to authorization. I don't think, and I don't purport to be much of an expert on the technical side, that the download can take place absent access to the phone through a password, which would have to take place relevant to the search protocol.
If the cell phones have not been downloaded pursuant to a prior order, that raises all the various things that Mr. Buzang presented in his opposition, which is the Commonwealth.
So when he walked into this courtroom, he was thinking, come on, Buzang, none of that stuff matters. You know it doesn't matter. It's not relevant. The stuff's already been downloaded from her phone. So why did you throw all that out there just for the cameras? And then he's like, well, actually then, Mr. Cosgrove, I guess if Mr. Buzang's right and you haven't downloaded this phone, all the arguments he made are completely relevant again. Looky there.
Having been in possession of the phone for an extended period of time has a finite amount of time in which it can seek authorization to search or to do the search. Let me just see for a second.
The judge is really trying to find the spot where it says that the phone was downloaded. He's really looking hard.
To 2024. Yeah. So in your motion, the Commonwealth's motion, it says on January 22, 2024, the Commonwealth sought a warrant for mobile devices capable of communicating in cell phones used by Karen Reed. After review, Krupp authorized the warrant. I am paraphrasing. Next paragraph. The search was executed on January 24, 2025 at 14:45 hours by Lieutenant John Fanning, who filed a return of service indicating seizure of 2 Apple iPhones, 1 purple with green case and 1 white with clear case. Is that seizure only of the phones, or is it the download of the information contained in the phones? Let me just see. I thought that there was something in here that said that there was a download, but maybe I mistook that.
If there's something in there that I picked up from an affidavit or a previous filing, I don't know. But my understanding is that the phones were seized.
Phones were seized and they haven't been searched.
No.
They haven't been.
And they can't be searched absent access to the phones, which require either the Commonwealth proceeding with breaking the, attempting to break the logon information.
Meaning they have them, they haven't downloaded them, they need more things, either the password or to use their computer program to break into the phone to be able to download it, neither of which they have done at this point, even though they've had the phones for a year and a half.
Or the receipt of the passcodes.
Okay. Well, so you've been in possession of the phones since January of 2024, and are only now requesting leave to download the information and search the phones.
Which is exactly what Karen Reed's team said they had a problem with and were frustrated by. Why now?
No, I think we already have leave to download the information pursuant to the warrant. What we have is a practical impossibility of downloading the information. What we're seeking is leave to do the search pursuant to a search protocol.
So he's saying we already can search them, but now we have a practical impossibility, and that's why I want to go through the protocol, and the protocol is what Karen Reed's team did not respond to.
As I understand it, Your Honor, there are two aspects to this. One is the physical seizure of the phone, for which the SJC has imposed proper requirements to get a warrant after the phones are seized, or in this case, there was a search warrant issued prior to the seizure of the phones. And the second aspect is the second search warrant to search the information. I don't think there's any basis for parceling out downloading as kind of a middle step here with a separate requirement.
Well, what do you say to Ms. Reed's argument, Mr. Buzang, that there's a certain amount of time you have to download if you have the phones, and now more than a year has passed, and it's only now being requested?
Well, there's no question that more than a year has passed, and it's only now being requested. And if Ms. Reed is right, I think that would be dispositive.
Meaning he loses. If Ms. Reed is right, that's dispositive and he should lose. But he doesn't think Ms. Reed is right.
But I don't think there's any basis in the case law for concluding that Ms. Reed is right.
And as we read the cases and the whole 123 days and all that stuff, to me, that's not like a bright line rule that the court has to follow, or else they would say you only have 123 days. That does not exist. We're going to hear them argue this. The point is, what's fair? What's justice? That's what we should be fighting for here. And it just seems like such a crock the way they go through this, and they're parsing it out like it's some complex legal issue that we're talking about. It's like no bill, hung jury, acquittal, jurors come out and say factually, what are we doing? Give her phones back. It's crazy. This feels, when people watch stuff like this, you understand why they get frustrated with the justice system, because this is BS from the prosecutor, and the judge needs to do the right thing. And he's going to give us some leans as to what I think he's going to do, and we'll see if that's what I think is the right thing, which what I think is just what I think, right? It's not the end all be all. Finding gifts for birthdays and other holidays feels impossible sometimes, especially now with everything and everyone being online. You can never really surprise anyone with something thoughtful because they've probably already seen it themselves. That's why I was pumped to find today's sponsor, Uncommon Goods, which is a unique online marketplace with a wide range of products that cater to different tastes and personalities, making it easy to find a thoughtful and personalized gift for anyone on your list. I'll be honest, when I first went to the website, I went right to the FSU gear and found this little zip pouch, which is absolutely perfect for me to put my tees and ball markers in for golf and leave it in my golf bag. And it is so cool with so many little details on it. But I kept looking, of course, for other people in my life. And I found what I think is a perfect gift for my wife this Christmas, because she loves those little Christmas villages with all the houses. But to make it even more personalized and more fun, I got the DIY kit. So me and my son can work together to build it and make it not only such a thoughtful gift, but she knows we put a lot of time and effort and spent time together building her one of her Christmas presents this year. And that's what's so great about Uncommon Goods. They make it really easy to find those kind of personalized and unique gifts, and you can get one today with 15% off if you click the link in the description below.
The case law suggests that a warrantless search of cell phones If that takes place, the Commonwealth must promptly seek a warrant, and the burden of justifying any delay is on the Commonwealth, whether or not the defendant presses for the return of the phone. That rule is designed to protect the defendant's possessory interest in the phone. And that, as I understand it, is based, among other things, on Segura versus the United States, 468 U.S. 796. Now, this case is not a warrantless seizure. It's a seizure pursuant to a lawfully issued search warrant. There are instances of items that have been seized in evidence that may have been subjected to tests years after the fact, sometimes as a result of new evidence or developments in the case. But where a warrant is obtained, the usual and accepted procedure, which so far I've seen no evidence that the SJC has changed, is that the Commonwealth retains the seized items until the conclusion of the case, which time the defendant may move for their return or the Commonwealth may move for other disposition. That's generally General Laws, Chapter 276, Sections 3 through 8. Now, I've looked at the cases that Mr. Buzang has cited.
And Diaz relates to a warrantless seizure of the cell phones and a delay in seeking a warrant to search?
Yes.
Okay. And
Yes.
here we have a...
That's very different than what we have here. What the defense is trying to cite is, Judge, this is unfair. And we have other cases where unfair things happened based on timing, and that's where they're getting the 123 days or whatever it was. That's what they're trying to argue, is not that there is a deadline of 120 days, but that we should fight fundamentally unfair action by prosecutors and law enforcement. And I couldn't agree more.
Warrant that authorized the initial search of the cell phones. Let me ask Mr. Buzang why that isn't dispositive. Is there a case that talks about a circumstance where there is a warrant that is issued to authorize the seizure of the cell phones, which is then where the ultimate search, the contents of the cell phones is delayed and therefore somehow prejudicial to the defendant and is suppressed?
I think, Judge, in this case here, the phones were seized January of 22nd, 2024.
Right, pursuant to my warrant.
To your warrant, exactly, right. Judge. And nothing's been done. The only reason something...
I understand, but do you have a case that says that when that's the circumstance and a year plus passes, they can't come back to the court to seek authorization to go into the phones?
The judge is like, is there a case that gives a deadline, or does the rule give a deadline? Clearly, the answer to that is no. But it's like, Judge, we have a very specific set of facts here that are very different than all the other cases. Look at this case, Judge. Look at this. Is not how things should be done. And the only way to keep them from doing things like they're doing to Karen Reed now, Judge, is to stop it.
When the court has originally authorized the seizure of the phones in the first place.
Well, I think Diaz, Judge.
Well, Diaz didn't involve a warrant, apparently, for the seizure of the phone. It was a warrantless seizure of the phone. No judge had viewed the contents of that phone as potentially, or had ruled that the contents of that phone were potentially evidence in a case, right? That there was probable cause or a basis to issue the warrant. So the question is whether you have a case that that arises in the context of a warrant authorizing the initial seizure of the phones, and then there's a delay in looking at the content of the phones or any other piece of evidence. You know, warrant authorizes the seizure of hiking boots, and there's a 1.5-year delay on doing DNA testing to see if the blood, if the boots trudge through mud or blood or whatever the relevant substance is.
Sure, Judge. Well, I feel that the reasonableness in delays in obtaining a search warrant under the Fourth Amendment, Article 14 of the Search and Seizure Law, requires law enforcement to act diligently to obtain a search warrant without unreasonable delay.
And here they did by seeking a search warrant for the seizure of the phones. The question is whether there's an independent, any case says that there's an independent obligation to seek further warrants authorizing looking at other aspects of the phone besides seizing the physical phone itself in a timely way.
Well, I think timing is relevant, Judge. They could have done it. They could have done it with the special counsel Mello. He chose not to. He went into the grand jury, which they returned a no bill. And Your Honor, this court knows better than anybody the level that requires an indictment to get issued. Here, they returned a no bill, Judge. I mean, there was less than any evidence that Ms. Reed conspired with Mr. Kearney to intimidate or participate in any intimidation of any witness in this case.
And that's also what my dad and I were talking about, where it's like no bill is like even less. Like it's such a low bar. Why are we doing this? It's crazy. And the judge, by the way, my dad and I were talking about all these tough questions he could ask the prosecutors as to why the delay, why are we doing it like this, why now, what do you plan on getting it? Do you really think that there was enough probable cause in the original search warrant? And the judge, of course, is about to ask 0 of the difficult questions of the prosecutor. I'm not saying this is a bad judge. I'm not saying he's in on some conspiracy or anything like that. I think it's like people don't want to ruffle feathers. They don't want to sanction lawyers, which I understand, but it's like we have to do what's right. We have to do what's right. When it comes on our desk, we've got to do what's right as lawyers, as judges.
But I think it is relevant in terms of now they want to come back and look at her 2 phones, and they have all that evidence from Mr. Kearney. They have, I think,
All right, no,
5 or 6.
I understand those arguments, but I'm still trying to find a case, if you have one.
And my dad was also right about the fact that the judge is not finding that a very good argument, that they already have Kearney's cell phone, which I agree with.
It comes up in the context of a warrant authorizing the initial seizure of the device, and then there's a delay in searching that device or searching that physical piece of evidence.
Just give me one moment, Judge.
Sure.
Head judge, but I think just, you know, I don't have a case off the top of my head, Judge, but I think just going back to the reasonableness under the 4th Amendment, I think again, this I don't think would have came up if we just let it stay and didn't ask for the 2 phones. It was only after I asked for the 2 phones that now this is somehow an ongoing investigation. When they've had the investigation was done, and there was nothing to it. If they had, and I think with this evidence, Judge, that they have, they can go back to 10 grand juries. They're going to get 10 no bills. But
Okay.
I think in terms of reasonableness and timeliness, Judge, I think, you know, it's almost 2 years.
Okay, I'll take it under advisement.
And the matter does.
So he'll take it under advisement, meaning he is not going to issue his order today. So we still have to wait and see what his order is going to be. But I think we're about to get to the part now where he's starting to show his hand a little bit.
Have a next date of December 5th.
Oh, you know what? I'm sorry, Margaret. I didn't get to the issue of if the warrant issues for the search of the phone, do you have any contest with the protocol that was set out by the Commonwealth?
I do, Judge. I don't think the Commonwealth, you know, in the preventive medicine case, the defense has some say in, you know, who would be a part of the taint team. So I don't take the representation from the government that they.
So he's saying, I don't like their procedure. I'm not just going to trust them with the taint team as to who's going to look at this. And the judge is like, that's what I wish you would have put in your motion that you didn't. Now we're talking about procedure if they are going to search the phone.
Should just set it up.
I don't have any opposition from you or any substantive response to you for the with regard to the protocol that's proposed by the Commonwealth. That was part of the frustration that I had with the papers as they came to me.
Crossing over. I understand, Your Honor.
Yeah, so there's a elaborate protocol laid out here in the Commonwealth's papers, and I need specific details as to what you're proposing if I'm going to authorize the Commonwealth to search through the 2 phones.
So Karen Reed's team kind of threw a Hail Mary. They're like, all or nothing, Judge. No way you should allow them to search the phones. We don't even want to talk about the protocol that they've produced. We don't want to give our kind of protocol because we don't think there should be anywhere near allowing them searching these phones. And the judge is like, I need your ideas on the protocol. What does that tell you? Well, if the judge had already made up his mind that he was not going to allow them to search these phones and he was going to give these phones back to Karen Reed, he wouldn't care about the protocol. He wouldn't care about these arguments. So I don't know that he is absolutely going to allow them to search the phones, but he has absolutely, as he sits here today, not made the decision to give them back to Karen Reed. So at the very least, he is still very seriously considering letting them download and search these phones. If I had to guess, I would think he is leaning that way. Now, one of the problems is I think he walked into this hearing thinking they had already downloaded it, no big deal. They have all the information. Now they're just going to look through it. That was completely wrong. He was wrong on that. He misunderstood or misread something in the Commonwealth's motion. I think what crept into his brain was logic. Like logically, they've already downloaded these phones. Clearly, there's no way they didn't download these phones. And it's like, but they didn't download the phones. So I think that was one of the problems coming in. And that's why he wanted to talk so much about the protocol, because I think he was going to allow them to search through all this stuff. And what's the protocol going to be? Because they already have the download, but they don't have the download. So I don't know if that nuance is going to cause him to potentially change his mind, but I think he's leaning on the side of allowing them to download and search through these two phones, which is wild to me. I can only imagine what they're going to try to find and twist.
I take it you can make a backup of the phones and do the search off the backup, and you can promptly return the phones to Ms. Reed.
I assume that's the case, Your Honor. I will check.
Okay.
But before we get to that, Judge, could I?
Then he says, I assume you can do a backup, whatever that is. These technical terms, everybody uses them a little bit differently, but I assume you can download the phone and give them back to Ms. Reed so she can have her phones. She has the possessory interest. We fix that. We grant their motion to give her back her car and now all three phones, and I can still potentially let you search the phones. Sounds like that's what the judge is going to do if I had to guess at this point, even though he has reserved ruling and not made his final decision.
Just have a couple of weeks to provide some opposition to that.
He asked for a couple more weeks to provide opposition to that. What do you think the judge is going to say?
Opposition to what?
To the tainting part of the government's motion.
No. You can talk.
He's like, no, absolutely not. You had your chance and you chose not to do it. You chose to swing for the fences. You chose to go for a Hail Mary. You chose to pretend like I was never even going to consider that. Guess what? I am considering it, and you've missed your opportunity to respond. But he circles back around and he does end up giving him 10 days.
To Mr. Cosgrove, the two of you folks can talk and
It's also like most judges, figure this out amongst yourselves. I don't want to have to deal with this. I don't want to have to make this decision. Can't you guys just work nicely together?
together, come to an agreement as to a protocol. And if there are any disputed paragraphs or sentences in that protocol, you'll show them to me in a document indicating that there's a disagreement as to this or that and the reason. Not a long brief, okay, not an elaborate briefing, but if I'm going to allow this, there's going to be a taint team protocol put in place. And
I'm currently in the process with co-counsel going through with opposing counsel, trying to create a document and agree. And it is so annoying. My co-counsel's doing most of the heavy lifting, but I'm listening to all the emails going back and forth and talking to my co-counsel like, you have the patience of Job, literally, because when judges want you to agree on a document, sometimes it is literally impossible between two lawyers, just so you know. But this judge is saying, work it out together, you two, make it happen.
assume you're going to agree to 95% of what the Commonwealth is proposing, and you may quibble around the edges. I've issued these before. Okay, it's not all that complicated. So I'll give you.
Once again, I've issued these before. It's not all that complicated. Makes me think he is going to allow them to download and search her phones.
10 days to do that. If that gives you folks enough time to confer with the idea that you'll reach agreement on most of it.
Very good, Judge.
Any problem with that? Is that enough time?
No, that's fine, Your Honor.
Okay.
So he is going to give him 10 days to respond here. So we're not going to have an order for a couple weeks on this.
I was happy to talk to Mr. Booth.
All right. I think there'll be very few things for me to resolve. So I'll give you 10 days. That'll be, what are we? We're already October 8. How about if you get it to me by the 21st, October 21st.
Good enough, Judge. Thank you.
And I'll take it in Word form so that I can make whatever edits I feel like I need to make to your version, taking one side's or the other's version. I'm likely to be more like a baseball referee, is take the version that I think without, fiddling too much with the language. So
As is every judge, they're going to take the version they mostly agree with. Not rocket science, but he's basically saying, give it to me in Word document. You guys all figure out what you agree on, what you disagree on, whatever you disagree on. I'm going to rewrite it, but rewrite it really by just picking which version I like better that you guys provided. This is lawyering, folks. Not glamorous, not exciting sometimes. Coming up with, it's not just like some people that aren't lawyers and have never done this before would probably think like, oh, make it this home run version. It's like, no, make it the right version, the most closely that fits the case law and what's been done in the past and what's the precedent on this, and write it closely to that. And the judge is most likely to agree with your version, not some wildly outlandish thing that's never happened before, but because the judge likes you better, he's going to pick your version. That's not what judges do.
both sides really need to be reasonable.
Understood.
Okay, 10:21.
Okay. So, we'll await your responses. You have until October 21st. And the matter's next on
Thank you,
December
Your Honor.
5th.
Thank you, Madam Clerk.
At 2 p.m. for hearing on the motions to dismiss. Thank you.
Brandel's like, I have just one quick thing to mention, Judge.
We'll see you then.
Your Honor, may I be heard on the disqualification issue?
So there are multiple cases against Turtleboy, and I guess Cosgrove has been disqualified from a different one, but not this one. And it's like, well, that's weird. And some of them are dealing with different victims, different witnesses. One of the victims, I believe, is suing Cosgrove or something. I don't know all the details, but I believe Turtleboy's lawyer thinks that they should be off, that Cosgrove should be off, and this entire DA's office should be off on every case. So how is he going to be able to do any work on this case, including what's happening right now with the cell phones?
Mr. Bradel, in what docket did you file a motion for disqualification?
Judge, I believe that was filed in all three dockets. This one is styled as an in-ray search warrant docket. It's 20, I have it right here, just 1 second.
When was the motion for disqualification filed?
I believe last week.
October 6th.
10-6? I'm not going to hear you on that until I get a response.
Sure.
So, I mean, the motion was only filed 2 days ago. It's fair for the judge to hear him on it, but it's also fair for this attorney to be like, I'm worried, Judge, if he's disqualified, he shouldn't be working on the case.
I understand you're right. It's just a little bit cart before the horse, I think, because counsel's forging ahead under a conflict. And, I don't think counsel for the Commonwealth should be permitted to keep forging ahead on this thing until the conflict issue is resolved. So I would ask that you stay any action on the part of the Commonwealth.
I will not.
until we-
I will not. I'll put you on for a hearing on a motion for disqualification. But I'm not going to do it on the fly or without everybody having adequate opportunity to be heard.
Sure. I understand. Your
When would you like to schedule a hearing on that motion? Margaret, do you have? We could do December 5th, but let me, do you have the motion for disqualification? I have an affidavit.
Sorry, Judge, there's an impounded and a redacted one. Redacted is for the public docket, and there should be an unimpounded one or unredacted in-ray search.
2025 case.
That's how, the
25 CR 88.
That's had a little bit of a back burner, Judge. I think there's a pretrial where it's in the pretrial phase right now in terms of discovery.
All right, but there's no disqualification motion filed in that one.
Correct, Your Honor.
Okay.
That's correct. The 24 case on the part of Mr. Carney, Mr. Cosgrove acknowledged and withdrew.
So there was one that they filed the motion to withdraw or disqualify, and he withdrew, agreeing he's disqualified there. It becomes problematic when you're disqualified in some cases and not others that are so inextricably intertwined that, like, if I'm a lawyer, I'm like, I'm out on all these. I want nothing to do with these cases that I'm disqualified or conflicted on. Like, I want out, but that's not what's happening here. No surprise.
The 23 case we contend
I'm sorry.
Sorry.
Say that again.
Sure. The 24 case on the part of Mr. Carney, that's 24-0043.
Yeah.
Mr. Cosgrove has acknowledged and withdrawn from that case, and I believe he's got a couple more weeks to confer with the district attorney and provide some sort of a replacement. The 23 case, we have now moved to disqualify him as for the same exact reasons why that apply in the 24 case, in the sense that Ms. Gattani is suing him and is also a key witness in the 23 case.
Seems like a problem. Seems exactly the same. Why would he not be disqualified? Why wouldn't he just withdraw from that case too? I don't get it. I like this lawyer too. I haven't watched a ton of him, but I like him. He seems good, smart, confident, controlling. I like it.
By the government's own admissions, the detective on the case swore to it.
Yeah, that's fine.
Sure.
So you haven't filed a motion to withdraw on the 2025 case.
It's like he knows he's got the goods.
Correct.
Okay, so we'll take up the 2020. We'll put all the cases on when it's an appropriate time to do a hearing.
Sure.
So when would you like to do the hearing?
Judge, could we do it a little before December 5th in November at some point? And if we can't get a date right this second, could we report?
Oh, you can get a date right this second?
Okay.
We'll figure it out.
Sure.
December looks better to me than November, Your Honor. And part of the problem I have is that in moving to disqualify me, particularly since Mr. Bradel has, or Mr. Kearney has moved as well to disqualify the Norfolk County District Attorney's Office.
So it's not just Cosgrove, the special prosecutor, it's the entire district attorney's office. And Bettero talked a little bit about this, I think, on the podcast. If not, I talked to him a little bit about it before.
Is who should respond to the motion to disqualify me? Should I respond?
It's like so confusing because everybody's getting disqualified here.
Should or can the Norfolk District Attorney's Office respond, or should it be the Attorney General or someone else? So there are discussions underway as to who the appropriate person is to respond to that.
By the way, these discussions, you don't ever want to be a lawyer having these discussions in court. This is not where you want to be.
And I expect it will take a little bit of time to hash that out.
Okay. We have a hearing date December 5th.
We do, Your Honor.
All right. It should be here. Yeah. What? No.
That's all I would move it.
Yes, it should be in this session, December 5th.
Very good.
Okay? And that's at 2 o'clock?
Yes.
Okay?
Thank you.
So, Mr. Carney, your matter is continued to December 5th for a hearing on the motion to dismiss and the motion to disqualify at 2 p.m. Thank you.
Thank you.
All right. So that's it. I mean, some fireworks, some things that just would only be normal in this case, right? It's very, very strange that this is how it's happening. This is how it's going. We're going to await the judge's order. If I had to guess right now, I think he is going to allow them to download and search the phone. If it were me, I would not, because at some point enough has to be enough. And although in most scenarios, maybe you would allow this, but not in a scenario with no bill, not guilty, acquittals, let her move on. But whatever, what do I know? All right, hit the like button if you guys haven't already. Let me know what you think in the comments. Till next time, peace. Thanks for watching another episode of The Lawyer You Know. If you enjoyed the episode, please hit the thumbs up and share with your friends who may be interested here on YouTube. And don't forget to subscribe. You can also follow us on Instagram, X, Facebook, and TikTok. And don't forget to check out the Lawyer You Know podcast featuring new episodes every week. And if you have a case that you want to personally talk to us about in your life, if it's a personal injury case, wrongful death, catastrophic injury, car accident, truck accident, or slip and fall case, please email us at lawyeryouknow@gmail.com. And of course, all these links I just mentioned are included in the description below on this episode and every episode. So until next time, this is Peter Tragos, The Lawyer You Know.